topic titled 10th Schedule of the Indian Constitution. The Indian Constitution is one of the most comprehensive and well-drafted constitutions in the world. The Constitution came into effect on 26 January 1950, establishing India as a sovereign democratic republic. Constitution Day of India, also known as Samvidhan Divas, is observed annually on November 26, honors Dr. B.R. Ambedkar and promotes awareness of constitutional values, rights, and duties. Constitution Day also reinforces democratic ideals, encouraging active civic participation and responsibility. The Indian Constitution is the longest written constitution in the world with 448 articles in 12 schedules and 25 parts. Among the 12 Asian countries that gained independence soon after World War II under drafted constitutions, but only 3 countries such as India, Taiwan, and South Korea's constitutions have survived. The Constitution of India is the supreme legal authority which binds the legislative, executive, and judicial organs of the government. The Constitution grants all citizens fundamental rights and independent judiciary to invalidate legislations or government actions which violate the Constitution. Some of the other features of the Constitution are federal system of governance between the Union and states, separation of powers between the 3 organs of the government, free and fair elections, equality before the law, and a secular state that recognizes the freedom of conscience and religion. The Constitution, drawn from various sources such as Government of India Act 1935 and the constitutions of Britain, America, Irish, Canada, Germany, Australia, Russia, France, South Africa, and Japan. The Indian Constitution covers a wide range of topics. As far as the different parts are concerned, the Part 1 of the Indian Constitution, titled The Union and its Territory, deals with the establishment of the Union of States, the Union's territorial boundaries, and the formation of new states. The Part 2 of the Indian Constitution deals with citizenship in India. Part 3 of the Indian Constitution deals with fundamental rights, include rights to equality, including equality before law, right against exploitation, right to freedom of religion, prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth, cultural and educational rights, right to constitutional remedies, and equality of opportunity in the employment. Part 4 of the Indian Constitution contains the directive principles of state policy, which are fundamental principles that guide the state functioning. Part 10th is about the administration of scheduled and tribal areas. It includes special provisions such as the establishment of autonomous district councils and a tribal advisory council. Both the central and states have a role to play in the administration of these areas. The Part 11th deals with relation between union and the state. Part 15th deals with elections, while Part 18th about emergency provisions. Part 20 contains the amendment of the Constitution. Schedules mentioned in the Indian Constitution. So the schedules mentioned in the Indian Constitution consist of many important information regarding the territories, allocation of seats in Rajya Sabha, the administration and control of scheduled areas and tribes, distribution of powers between the central government and the state government, along with emoluments and privileges of high-ranking officials. The 10th schedule of the Constitution contains provisions relating to disqualification of members of parliament and state legislatures on the ground of defection. It was inserted through 52nd Amendment Act in 1985. The 10th schedule of the Indian Constitution related to Article 102 and Article 191. The introduction of the 10th schedule in the Indian Constitution was aimed at curbing political defections. Though the law has succeeded in a reasonable way, but due to some of its loopholes, it has not been able to achieve the best it can. The 10th schedule does not include any specific rules or provisions pertaining to unattached members, leading to differing interpretations regarding the treatment of unattached members. The implementation of the 10th schedule has presented new challenges as presiding officers have exhibited various interpretations. While courts have validated certain decisions of the presiding officers, in other cases, they have overturned them, creating inconsistencies. As far as some of the articles, important articles include, important amendments to the Constitution include, in the recent years, 102nd Amendment Act of 2018, it gave constitutional status to National Commission for the Backward Classes. 103rd Amendment Act of 2019, it provides 10% reservation for economically weaker sections. 104th Amendment Act of 2020 provides the reservation of seats in the Lok Sabha and state legislative assemblies for the members of scheduled caste and scheduled tribes till 25th January 2030. 105th Amendment Act of 2021, it has reviewed powers of the state governments to identify socially and educationally backward classes. 106th Amendment Act of 2023 reserved 1/3 of all seats for women in Lok Sabha, state legislative assemblies, and the Legislative Assembly of National Capital Territory of Delhi, including those reserved for SC and ST. To have a detailed discussion on the implementation of 10th schedule of the Indian Constitution, Sakshi Education has invited two eminent speakers. The speakers are Dr. K. Vinay Kumar, Assistant Professor of Political Science from Maharashtra National Law University, Aurangabad, and Mr. Nishit Ranjan Chaki, Assistant Professor of Law from KCC Institute of Legal and Higher Education, Delhi. The first speaker of today's webinar is Dr. K. Vinay Kumar. Dr. K. Vinay Kumar is working as an Assistant Professor of Political Science in Maharashtra National Law University, Aurangabad. Before joining Maharashtra National Law University, Aurangabad, he was working as an Assistant Professor of Political Science at Geetam. He has more than 8 years of teaching and research experience. Currently, he is heading a Center for World Affairs at the university. He has 3 edited books to his credit, titled The Elephants Rise in the East, Navigating India's Foreign Policy in an Emerging Multipolar Asia, Terrorism and Technology in the 21st Century, Issues and Challenges, Global Geopolitical Impacts and the Dynamics of Indo-Pacific. He has presented papers at national and international conferences and contributed chapters in edited books. His areas of interest lie in energy security, renewable energy, climate change, terrorism, Indian foreign policy, and face militarization. Dr. K. Vinay Kumar frequently appears on international news channels such as AI Carrera, Ashraf News, and Bloomberg Dubai to discuss various global issues. Now I request Dr. K. Vinay Kumar to speak on understanding the anti-defection law and political party dynamics in India. Welcome, Dr. Vinay Kumar.
Thank you. Thank you very much, sir, for introducing me. It's my pleasure to be a part of the discussion today. Uh, as I'm very happy to be a part of this discussion, and I'm thankful to the Coterie sir and ICFI group of institutions, and along with the ICFI group of institutions, I'm thankful to the Sakshi Media Group for inviting me to be the part of this wonderful discussion, and thank you once again for giving me this opportunity. So, if you permit me, I would like to share some of the slides to make sure that it will be visible for the people to understand it in a better way. Today, let us discuss about the anti-defection law in India and how this concept of anti-defection has emerged, and what are the political factors that led to the emergence of this anti-defection law. So initially, if we look into the freedom struggle, as rightly pointed out by Coterie sir, that the freedom that we have gained from the colonial empire or the colonial regime during the period of the struggle for freedom, every party, regardless of their ideas, their inclination towards the ideologies, they were on one aim, that is to make sure that India gets freedom from the clutches of the colonial empire. So keeping aside all the all the differences, all kind of inclinations, all kind of ideas at bay, so, what is the historical background for the emergence of this anti-defection law in India? I was just emphasizing and rightly pointed out by Coterie sir that during the colonial regime, every political party, regardless of the inclination and ideas, all were with an idea that we need to get freedom at any cost. So, keeping aside all those ideological inclinations and party affiliations, whether it may be communist, whether it may be right, whether it may be extremist, or what it may be, keeping it aside, they started with an aim to free the country. But after the liberation of the state from the colonial clutches, it has come to essential thing that we need to have a democratic setup. In a democratic setup, the political parties play an important role, and the political parties, especially after the independence, though the Congress initially stated that it would not going to be a political party by it was stated by the Mahatma Gandhi that it would not be a political party after getting the freedom. But this was not the case once the freedom was achieved by the Congress party. And it was an essential at the point of time that there should be a leader. There should be a leader who is stick to the values, sticks to the ethical principles, so that they can lead the country towards a proper direction. And this has, in fact, maybe turned the Congress party toward to take a turn to be a political party. Now, once the Congress become a political party, majority of the people have joined the Congress party, and and they captured majority of the seats in the first general elections, that is in the 1952. though there were some independents and some political parties, but they could not get any substantial majority in either state legislative assemblies or at the national level in the parliament. This was the case in 1952 and 1957 and 1962, and the turn of events has come in the 1962. In the 1962, if you go back to the political history of India, because of the huge policy lapses, crop failure, and corrupt practices of the Congress government, then these all have led the people to look for an alternative. Now, in the fourth general elections that were held in 1967, during these general elections of 1967, if we look at the party configurations or the number of seats that each party has got, this is the first time when the Congress could not enjoy the substantial majority in the parliament. Though it has got a majority, but it was not a two-third majority which it has enjoyed in the previous elections. So we can consider that the 1967 election, that is from 1967 onwards, there has been a scope for the defection, more defections. If you look at the parliament configuration in 1967 general elections, the Congress got 283 seats, whereas the Swatantra Party, which is another party that has got 44 seats, and the Janasangh has got 35 seats. In fact, there were independent members; those have contested and got elected also. And successfully, the Congress government has installed its government at the national level. But at the state level, it has faced the troubles for the installation of the governments led by the Congress party. In the fourth general elections, when almost 16 states went for the election, out of the 16 states, majority of the states, that is, half of the states have been lost by the Congress party. The Congress could form the government only in 8 states out of the 16 states.
Only 12 participants.
So, the Congress could secure, half of the seats which it has contested, half of the states which it has contested. For example, I was just emphasizing that before 1967, it was enjoying a considerable majority at the central legislature and also at the state legislatures. But in the 1967, there was a turn of events, and this was not the case in the state legislative assemblies, ranging from the Bihar, Punjab, Madras, and other places. The Congress government has lost its seats in these legislatures. So, if you take into consideration of the figures that the Congress has been deficit to form the government, in Rajasthan it has been short by 4 seats, and in Punjab it was short by 5 seats, and in UP it was short by 13 seats, and in West Bengal, it was short by 14 seats. And in Bihar, which we are going to discuss further about this which we are going to further discuss about this Bihar situation and what led to the defection in Bihar. So Bihar was short of 32 seats to form the government. The simple majority I'm talking about. So nearly after 2 months of political drama by the Congress, somehow it has managed to fetch the 4 seats in Rajasthan and form the government. But when we look at the other states, it was difficult for it, especially the Punjab, especially the Bihar, especially the West Bengal, and these states have faced a lot of problems in the formation of the government. Let me give you an example of the Bihar. If you take the case of Bihar, in Bihar, this the case of anti-defection was unraveled in the 1967. Now, in case of Bihar, there was around different parties that have contested. No single party has got the majority to form the government. Um, you know, the Samyukta Socialist Party has emerged as one of the largest party in the state of Bihar, but it could not reach the majority to form the government. So, along with the Samyukta Socialist Party and Samyukta Vidyadik Dal and other parties have come together and formed a government with 14 ministries. And once the government has been installed, the people who haven't got the portfolios, either the ministries or the important portfolios, or it maybe, these people started to look for the alternatives. So what happened in these people started to look for the alternatives, and as a result, the government has collapsed in the Bihar. Now the dissatisfied rebel MLAs, we say, went to the other party, got divided from the government, and they have formed Soshit Dal. So this Soshit Dal, along with the Congress party, has formed a government in Bihar after a year. That is from 1967, almost in 1968, the Congress and the Soshit Dal has formed a government. But this government could not succeed for a long period of time because of the dissatisfaction that has been expressed, that has been there in the people who had contested in the elections and won the election, because they could not get this portfolios, important portfolios, and this has been continued until 1970s. And within this span of time, there was around 2 years where the Bihar drifted into the political crisis. Sorry, and the presidential rule was imposed. So here, from the fourth general elections onwards, the concept of defection has come into the prominence. It doesn't mean that earlier there was no concept of defections in the Indian political scenario. Earlier there was there, but not so prominent as it has been seen after 1967. So if you look at the data that have been provided on the screen, hope you would be able to see it. So between the fourth and fifth general elections, from 1967 to 72, out of the 4,000 legislators, nearly half of the defections have taken place in the country. That means out of the 4,000 legislatures at the central level and at the state level, nearly 50% of the population have crossed the floors, have crossed, defected from one party and went to the other party. Now, what are the, there was a private member bill that was introduced to overcome this kind of defections in the near future. Uh, in the 1969, Venkata Subbaiah has introduced a private member bill to make sure this kind of immoral acts cannot be allowed by the parties, the respective parties, and there should be a code of conduct that has to be imposed by the legislature on the elected members of the parliament and the state legislatures. So this has come to the discussion in the 1969, and initially there was a code of conduct, but it has been referred to the committee. A YB Chavan committee was framed, and this committee has worked for nearly 2 years, and it has submitted its report to the parliament in 1969. And in 1969, there was a discussion for a bill that has to be introduced in the parliament to curtail these defections. Now, though almost all the parties, regardless of ideologies, have consented for the enactment of this particular bill, but because of the midterm elections and because of the political crisis that India has faced from 1975 to 77, and then there was Janata Party government that could not withstand, and after that, in 1985, they built a consensus on the anti-defection law. What are the main aspects of this anti-defection law? This anti-defection law, if you look at the etymologically, that defection means crossing over the floors. That means if a person X or Y, he was elected or representing one political party or an organization, and upon election from one particular political party, he has crossed to another political party on which he was not elected. So defection means going from one political party to another political party. So it has been introduced by the Prime Minister, the late Prime Minister Rajiv Gandhi, and it has come into force on March 1st, 2025. And it added one more schedule to the Indian Constitution, that is the 10th schedule to the Indian Constitution. What are the various provisions of this act? What exactly the gist of this act or the essence of this act? The act provides that if any member of the parliament or a legislative assembly fall vacant in the following terms. That is, if a member has been elected from one political party and he has joined other political party, then his candidature in the central legislature or the state legislature will be fortified. He cannot be a part of this particular legislature until and unless he resigns to that particular seat and go back to the constituency for the election purpose, and he has to contest the elections and come back again as a member of that particular party wherever he has crossed to. Now, there is one more provision that has been included in this 10th schedule, that is, in case if a party X or Y is issuing a whip to all the members of the legislative assemblies or the parliament, that in case of the discussion of an important bill, or in case of any in case of no confidence motion that has been moved in the legislatures, then it is the responsibility of the particular member to which he or she belongs to come and present in the parliament or the legislature to vote in favor of that particular bill according to the wish of the particular political party which he represents. And in case if he is absent for voting, or if he acts contrary to the whip that has been issued by the party, then he has to be disqualified from that particular legislature. There is a provision which there is an exception, of course, that the concerned person has to give an explanation to the concerned party within 15 days. In case if the party is satisfied with the reason that has been expressed by that particular member, then it can be exempted from that particular action. And also, one more factor that has been added into this anti-defection law is that in case if a member who has been elected independently joins any political party, or if a nominated member joins any political party after the 6 months from the date of his oath, it means if I been a member of a legislative assembly or the parliament who has been nominated by a party X, if I'm joining any political party after the 6 months of my oath taking ceremony, then it is deemed that I am disqualified for for being a member of that particular legislative assembly or the parliament. Now the question comes is that there are some few exceptions to this. This is where the most of the political parties have been facing the problems after the anti-defection law has been passed in the country. That is, the exceptions are that in case if there is a split in the party, that is, in case if 1/3 members of that particular party has dissociated themselves from the political party to which they belongs to and forms a separate group, then there is no action that has to be initiated against the members of a separate bloc that has emerged from the split of the original party. Now you take the case of the recent Maharashtra political crisis, where the Shiv Sena Shinde party has dissociated itself from the main Shiv Sena Uddhav Thackeray party and formed a new entity, the Shiv Sena Shinde faction. So in that scenario, there is a possibility that these members should not be disqualified from the legislative assembly or the legislative assembly, or in the case of parliament that might be happen. In case of parliament, if you take into consideration about the formation of the VP Chandrasekhar government, the Prime Minister Chandrasekhar government, when the VP Singh government has a majority in the parliament, the Prime Minister, the late Prime Minister Chandrasekhar ji has had a difference with the VP Singh government, and he had a split, and majority of the people have joined the Chandrasekhar government. The Prime Minister Chandrasekhar ji had formed a government, um, and of course, this government could not stay for a long period of time. It was there for 232 odd days. But uh, in such scenario, the speaker, or the deputy speaker, or any designated member of that particular party, of that particular house, has no right to disqualify these members. At the same times, in case if the two-third member of the particular party gives the consent for the merger of that particular party into another party. For example, to take the case of the Prajarajam party. Now, the Prajarajam party, hope you remember that in the Telugu states, the Prajarajam party was formed by this the film actor, the Telugu film actor called Chiranjeevi. And later on, he was uh, satisfied with the portfolio that was given by the Congress government, and with the coalition with the Congress government, initially he has merged his party into the Congress. We all know that situation or circumstances, or what it may be. Now, there is one more thing, that is resignation of the speaker, deputy speaker, chairman, deputy chairman from the party membership. Now, in case if a member of a X party has been elected as a speaker of a house, or a deputy speaker of a house, or a chairman of a house, or deputy chairman of a house, now he has to, resign to his primary membership of that particular political party, because as we know that that this position of the speaker and deputy speaker and chairman and the deputy chairman is neutral, and it should not be inclined to any of the political parties. Now, let me explain you the contentious issue of. Okay, let me explain you the first case that has come after the this anti-defection law has been enacted. Now, the Speaker of the Kerala has got an opportunity to deal with the case of disqualification under this anti-defection law in 1985. In 1985, against the PC Thomas. The PC Thomas originally contested from the Democratic Janata Party in 1985, and he later on shifted his affiliation to the United Kerala Congress in February 1985. Considering the situation, the Democratic Janata Party of the Kerala government has given a letter to the speaker stating that that person, the PC Thomas, has to be disqualified under the anti-defection law. But as I was just explaining you earlier, that this act has come into force on March 1st, 1985. So this incident, or this act has been committed by the PC Thomas in 1985 February, stating that the act has come into force on the 1st of March 1985, and this act of affiliation, change of affiliation, has happened in February 1985. So the speaker has absolved this issue, and there was no action that has been initiated against the PC Thomas. And after passing this, let me explain you about this paragraph 7 of this anti-defection law. The paragraph 7 of this anti-defection law clearly states that uh, clearly states that the speaker or the deputy speaker, being a neutral party in the house, either it may be the central legislature or the state legislature, it is the responsibility of the speaker to take an action on these acts which are committed by the member of legislative members of the legislatures. The paragraph 7 states that the speaker has an authority to decide the case regarding the disqualification of the legislatures, disqualification of the legislature either in the parliament or at the state legislative assemblies. But this has been turned into a lot of controversies. As we have discussed just now, that the seat of speaker or the chair of the assembly or the chair at the parliament, the procedure that need to be followed for initiating any anti-defection process against the member of a legislative assembly or the member of parliament is that the particular party to which a candidate belongs to has crossed the floor. That particular party has to submit submit its request to the Secretary General of the Parliament to initiate the action against the member who has crossed the party. Now, it is the responsibility of the speaker to make sure that the party who has been crossed the floor has to reply to that particular letter which has been sent by the speaker within 14 days of the recipient of that particular letter from the speaker. But this process has been again and again pointed out that this process has been not followed in any of the defections that takes place at the state legislative assemblies or at the parliament level. If you take the case of the state legislative assemblies, the speaker of the state legislative assembly has to initiate the proceedings immediately after 14 days. But you can look at the different situations either in the state of Telangana, in the state of Maharashtra, in the state of Haryana, or either in the state of Goa. Goa, especially from 1991 to 1999, there were around 11 governments that have been formed in the entire decade of from 1991 to 99. 11 governments have been installed in Goa. So this is how the defections are more prevalent in different state legislative assemblies. And the controversial aspect is that the speaker, who has to be a neutral party or a neutral member to take and decide the cases in case of defection, being a political representative, either it may be the case of any state, the party whichever that gets the majority would be appointing the speaker of that particular legislative assembly. Now, in that scenario, it is quite surprising for anyone to know that the speaker would act against the party which he or she is representing. So this is what the contention is, that being a member of that particular party which gets the majority and being appointed by that particular party which gains the majority, it becomes very difficult for us to understand that how a speaker will act the against the a party which is ruling and which has appointed him to the chair. So this has been contended by the members of the opposition now and then, again up to the recent the states of Maharashtra, the governments also. In fact, the speakers were not being the neutral is one of the significant aspect of this anti-defection law, where the speakers started to act in favor of the ruling governments. During the TRS government, for the sake of a better understanding, during the TRS government, the Congress party, majority members of the Congress party have given representation to the speaker, stating that the Congress party has to be dissolved into the TRS party, and the Congress party has initiated proceedings against the members who have given a representation for dissolution of the Congress legislative party into the TRS party. But no action has been initiated for nearly 10 years or so. So this itself reflects that what kind of defection defection law has been implemented in the legislatures. Now the contention is that if you understand the various aspects of this defection, for example, we may say that as argued by Palkiwala, that in case if a party member, if an MLA or MP has changed his ideas or has been undergone a shift in the ideology from left to right or right to left or what it may be, so doesn't he have a right to express his views in the parliament or in the assembly, or doesn't he have the right to join any political party? That's the issue. That Article 19(1)(a), B, and in fact C, that is freedom of expression. If we look at the acting of a member in contrary to the party directions, his freedom is rightly curtailed. The freedom is rightly curtailed. He cannot express the views that he has in case it differs from the directions of that particular party, which is the party belongs to. And other factor is that he has a right to join any group. And 19(1)(a) and B says that he can act according to his conscience. And she says that he has the right to form any association. So, is it not in contradiction to the Article 19 of the Constitution? And in fact, if you look at this anti-defection law from a theoretical perspective, if you look at from the Machiavellian perspective, there is nothing wrong to shift the affiliations to any political party, because as we know that in political, as we read the Machiavelli, that it has clearly stated in the Prince that the personal morality should be differ from the private morality. So in that situation, being a selfish individual and being a person who wants to capture the power, there is nothing wrong from this perspective. But at the same time, if we look at the perspective of J.S. Mill in his text of on liberty, if we look at an example of a family, now unless and until he is alone and if he's not affecting the other member of the family or other members who are in relation with him, he has a right to do anything without entering into the rights, without transgressing into the rights of the other people. In that situation, to a certain extent, he has a liberty. But J.S. Mill emphasizes that, in case of his responsibility to the people who have elected him, in case of the people who has entrusted him by seeing the political party he or she belongs to, being a public representative, he has no right to cross the parties. He has no right to cross the party to the other party because he is answerable to the people of the state. Because by crossing to the other party, by going over to the other party, it means it is affecting the rights of the people of the state who has elected him. So, in this perspective, it is clearly true that it is against the morality, the public morality. It is against the democratic setup of the political, democratic setup of the constitution. But from understanding from a different perspective, looking from the party perspective, as we know that in India we have different parties, not a single party. There are different regional parties with various ambitions and ideological ambitions and personal ambitions. They have the different parties. We have different parties in our country. In case if a strict party affiliation has been not followed, in case if we allow the people to act in contrary to the decisions or the directives of the political party, it becomes very difficult for the legislatures to make the laws or to frame the laws or for the smooth conduct of the governance in state. Because in case of the people given a freedom to act independently of the directives of the party to which he or she belongs to, so this will create a problem in the democratic setup. He or she will be voting according to the wishes and will of an individual, and as a result, no policy in the state would get the consent of the legislatures, a consent of the legislature, and no policy can be implemented in the state.
Mr. Nishit Ranjan Chaki. Mr. Nishit Ranjan Chaki is an assistant professor of law at KCC Institute of Legal and Higher Education. This institute is affiliated to Guru Govind Singh Indraprastha University, Delhi, NCR, Greater Noida.
Namaste, everyone. So I have been given the topic of impact of 10th schedule on the coalition politics in India. So as our very respected last speaker Vinay sir has told about the origins of the coalition politics and what are the practical effects of this coalition politics, and he has also highlighted that what are the two sides of the coalition politics, why it is good and why it is also facing the problem of defection. Now I'll take the cue from his last observations about freedom of speech and expression, sir. And you have told about Article 19 and also the right of political dissent. And with that, I'll be trying to deal with the topic from the right of political dissent and from the right of from the issue of defection in Indian politics. So a very interesting thing that I would first like to refer is that Winston Churchill was also a defector. So he was elected in the Conservative Party and he moved to the Liberal side. And even after, just imagine that even after winning the Second World War, he lost the elections, the general elections. So when we talk about democracy or when we talk about voting behavior, when we talk about political behavior, uh, theories can be given. Theories have been given by eminent scholars, but people tend to vote on more on emotions also. Emotions play a large factor, and the connection with the local leader that play a large factor. Now, interestingly, when the Anti-Defection Law, as we know it today, the 10th schedule, that is 52nd Constitutional Amendment Act was passed, the then Congress government was having a huge majority, and there was not even a single vote against this constitutional amendment. So I'm talking about 1985. There was not even a single vote against this constitutional amendment. So it shows the unanimity that everyone was agreeing to this to the passage of this anti-defection law, because as sir has already highlighted, after the fourth general elections from 1967 to 73 there has been a widespread defection. And since the colloquial term that is being told about this defection is Ayaram Garam, it also has its origin during those days. Now, what is important to understand in this entire defection politics is that there is an interplay between the national political parties, the parties that hold power in the nation, in the country level, and the political parties that are holding power or having their stronghold in the states. So, in this case, defection, I think, is also an issue of federation, of designing the political federation of our country, and it is also a issue of heterogeneity of Indian population. On the negative side, defection, why it is required to nip the bud of this problem of political defection is that it will create unstable governments. The thing is that the right of freedom of speech and expression and the right of political dissent, that is okay. But when we talk about defection, the primary argument that is taken when we want to curb the evil of defection is that it creates unstable governments. Not only that, it creates what is known as the devaluation of the constitutional functionaries. For example, the chief minister's post, it devalues the chief minister's post, or even the prime minister's post in some cases, because we have seen in history that some defectors went on to become the chief minister, went on to become ministers, and went on to become prime ministers also. Now, when we talk about 10th schedule of the constitution, it is to be remembered that the 10th schedule is to be read with other provisions of the constitution, which are Article 103, Article 74, Article 101 and 102, and Article 122 and 212. So, taking from the starting, if I say about the origin of the 10th schedule, the Constitution, 32nd Amendment Act, and the 48th Amendment Act, not act, the bill was, it was tried to pass a bill, the Constitution 32nd Amendment Bill and 48th Amendment Bill in 1973 and 79 respectively, it failed. After that, we have the 52nd Amendment Act 1985. Now, when we have introduced this 57th Amendment Act 1985, it recognized the concept of split, right? Under paragraph 3 of the 10th schedule, there was a concept of split, that if you are having a dissent with your own political party, you can go and split that political party if you are having a certain number of requisites, member of parliament or member of legislative assembly. And after that, through the 170th report of the Law Commission 1999, the Goswami Committee report, the National Commission on the Review of the Working of the Constitution report under 2002, it was found that the provision of split was being, it was being misused by the legislatures. They were hiding under the cloak of split when they actually wanted to defect from the party, right? So whenever there is a very thin line of division between this freedom of speech or expression and right of political dissent and the outright defection. Outright defection generally happens only on cases of personal motives. If you have a lure for the constitutional office, if you want to become the minister, if you want to have some financial consideration on the part of your defection, on the part of your political behavior, then it outrightly becomes a case of defection. And this is the reason that in other democracies there are no such laws of anti-defection, because those democracies work in a different manner in which the people, the legislatures or the ministers are more accountable to the people. Now, if you see the latest case, the most interesting case that happened in India regarding this defection issue was in 2022, I think 2022, 2023, it was a case of Maharashtra crisis. Two crises was there in Maharashtra. One is the Shiv Sena crisis, and thereafter also another political party faced a huge crisis in Maharashtra. Now, what happened that now we have the election results, right? Now the elections have already been done and election results are there, and we can see the how the people voted. So all these technicalities are aside, and the voting behavior or political behavior is a different. So that kind of gives the fuel to the fire of defection. So as per the definition of Subhas Kashyap and also the definition given by the committee based on whose recommendations the anti-defection law was primarily designed, defection always occurs on the cases of personal motive and on the cases of personal favors that one can get from the government. So after the passage of the 170th Law Commission of India reports, the Goswami Committee report, and the review of the working of the Constitution in 2002, there was another amendment, the Constitution 93rd Amendment Act, that comes in 2003, and it removes the provision of split. Under paragraph 3, it removes the provision of split, and also it does an amendment of certain other provisions. And now the present situation is that if earlier what used to happen, that in order to lose the legislatures of opposite party, there was a offer of office of ministerial birth and all that. Now it is clear that up to a certain percentage only you can have your council of ministers, and there is a maximum limit, and there is also a minimum limit in certain cases. So it acts as a check, a constitutional check on the misuse of this power of allocating ministerial responsibilities amongst the legislatures from opposite party. So even after the 93rd Constitutional Amendment Act, now at present we have two dilemmas. If we look at Article 101 or Article 102 of the Constitution that relates to the Parliament, then we have the provision for disqualification. Now, in that provision, the constitutional functionaries that deal with the disqualification are different. Now, the Election Commission had in 2004 given a report that the anti-defection law should also have similar kind of constitutional functionaries, like the president, like the governor. And under the 10th schedule, the constitutional functionaries who decides on the cases of defection are very different, as you know, as Sir has also explained. Those are the parliamentary functionaries, already member of parliament, and they are also dependent on the support of the majority in order to hold their respective offices. So now coming quickly to the legal repercussions of this anti-defection law, there are three areas which are needed to be dealt with when we understand the anti-defection law. First, the speaker's power is not suo motu. The speaker or the chairman or the deciding authority, although the chair acts as a tribunal, and it is presumed that the chair will act impartially in cases of deciding whether there has been defection or not, but it does not act suo motu, right? So when the certain amount of people has elected a legislature, and that legislature, member of parliament or state legislature assembly defected from the original political party, I'm just using the colloquial term original political party. So if they have defected from that party, and now after that somebody needs to complain to the speaker, they need to raise an objection and put in a formal complaint for the speaker to act. It cannot act suo motu. Now, when we talk about this kind of cases, then either the speaker can act under a complaint, obviously, or it cannot, or the speaker is virtually helpless, as no steps can be taken about the defection. Now, what happens when we are having a perspective of voters' accountability over this issue, right? The voters might have a say over whether the legislature did a right thing in defecting, or whether he or she did a bad thing in defecting, right? It is a question of political morality, but the voters does not have any legal recourse in this case. No voter can raise an objection. The people who have voted, actually, they cannot raise an objection. They have nothing to say in this. Now, the second thing is that when we understand defection, in case of the present scenario, we are dealing with we are dealing with a slight of a legal fiction here, as we have seen in the Maharashtra case, as decided by the Supreme Court, that what is the main political party and what is the legislature, the political party functioning in the legislature. So when it comes to certain thin lines of legal fiction, then it is obviously that under the reasonable and to a reasonable person or a reasonable mind, it is very clear that the party which puts up a candidate for the election, and the party which favors a candidate on whose manifesto the candidate get elected, that is the political party. And if we see the present the dilemma between this political, which what is the original political party and what is the legislature party, then the accountability of the legislature party or the accountability of the individual legislatures is to the political party. Because the definition of defection is all about the membership of political party, or not accepting the decision of the whip of the political party, voting against a particular political party. So the accountability is to the political party, and accountability is not to the voters. So here it comes that the right of freedom of speech and expression and the right of political dissent gets really challenged. Now, what about that? If the right of political dissent gets really challenged, then what can we do about it? So obviously, if we now shift our gaze to the decisions of the Indian Supreme Court, then the first case that came around in this regard is Kihoto Holoha versus Zashidu. It is a case of 1992, and in that case itself, in the last few years, when the Manipur crisis occurred, and the Supreme Court has referred to this case also, it's a very landmark case. And in this case, the court took a restrictive view of the direction issued under the meaning of the word direction issued under paragraph 2. The court took a restrictive view in view of the provisions like Article 105 and 194. Article 105 and 194 protects and talks about the freedom of speech and expression of the members of the parliament. So it took the view that only those matters which are integral to the political party, which are very much integral to the political party, and on matters like no confidence motion, there can be we can have a mandatory requirement that a party candidate who has been elected should behave in a particular way. Otherwise, the court also recognized the fact that when the speaker acts as a tribunal and the speaker decides on the cases of disqualification, then the speaker is not always immune from all the vices of human personality that we as a human being face. For example, we will be supporting a political party, we will be getting elected on the votes of certain majority to become a constitutional functionary, and then how can it be ensured that we are acting on an impartial manner? So this is the case. It was recognized in this the case itself, the balances between the freedom of speech and expression and the dissent. So it was the case of Kihoto Holoha versus Zashidu. After that, what happened that under paragraph 8, the speaker can frame rules. Under other paragraphs, other provisions also, the speaker can frame the rules regarding the defection. So the Supreme Court held that these rules, when we talk about the bar of judicial review, that the speaker's decision has been is final and no court can interfere with the decision. So when we talk about the bar of judicial review, in that same case, the court held that in order to create a limitation on Article 136, 32, or 226, it needs to be amended in a particular way. And since this was not done, so there is not a complete bar on judicial review, and the Supreme Court can interfere in these cases when there is a blatant violation of the principles of natural justice. But when the decision of the speaker is pending, at that time the court cannot enter into the matters of that individual complaint. So, as we can see that the court told that if the matter is sub judice, if the matter is under the consideration of the speaker, then the court will not interfere. The court will not be in the position to entertain the petition about the whether it is valid or invalid, whether it is unconstitutional or not. But in the Maharashtra case, we have seen that the court did took a stand when the decision was still pending, kind of. So what happens is that in the political dynamics, in the development of the party system, in the development of the political dynamics, certain things like the issue of defection depends very much on the political morality also, and on the understanding of the constitutional principles as such. So, as an impact of as a what the coming back to the main topic, that is the impact of 10th schedule on the coalition politics in India. As far as we can say, there is a very reputed author on constitutional law, and he states that only two speakers have been very much impartial and also had the legal acumen to deal with defection proceedings. And rest of the speakers and rest of the constitutional functionaries are not that adept in dealing with the defection proceedings, nor can a brand of impartiality be presumed over any such or every such constitutional functionary. Having said that, I think that at the present time, many political parties, and mostly the news that is being highlighted, all the news that we see, there has been several instances where the political parties has created loopholes in the law, or they have not created, they have looked for the loopholes in the law, and they have become immune to the challenges of defection. As sir has, the last speaker, the respected Vinay sir, has already talked about the Maharashtra case and how the resignations happened and how the real Shiv Sena and the other faction came to be recognized and all this. So mostly the political parties have already started looking for loopholes and has operated through these loopholes. Now what happens is that under such cases there is a term called judicial interference or judicial intervention. So that cannot happen. The positive side will be judicial supremacy. Now, for every action of the parliament, of every action of the speaker, every action of any constitutional functionary, we cannot go to the Supreme Court and move the Supreme Court. So there are certain stages. We can go to the High Court, then we can go to the Supreme Court. Even if we are going to the Supreme Court, it must be a question of fact, basically, interpretation of the rule of the Constitution and all. And we cannot expect the court to administer the country or the court to be the guardian of this kind of parliamentary procedures, because it is a question of constitutional conventions, what we understand as convention, how we behave as individuals. So in this thing, I think that the way forward, the recent cases have been, and all the cases up till now had been, that the 10th schedule has been kind of misused by the political parties, and they have devised ways in which they can avoid the repercussions of 10th schedule. And even if you go into the 10th schedule and there are certain other procedural matters, the court will not interfere. And if there is a blatant violation of natural justice and all such, in that case also the court will be limited in its approach, because in the case of the Maharashtra, the CM resigned before the floor test, right? So it was a political decision. It was a purely political decision, and it is a good decision, given that what the political circumstances was there. But the Supreme Court, even after clarifying the law, even after explaining what is the legal provision, and even after taking a certain kind of stand which is anti-defection, right, and yet could not reinstate the government because there was a voluntary resignation. So in these cases, it will be very much dependent on our political actors to understand this law of defection. And as I have said that in 1985, when this law was passed, there was not even a single opposition vote to this law. At present also, we need some unanimity in order to make India more stable politically and in order to reap the benefits of our heterogeneous democracy. In this point, I would like to conclude that yes, there is a freedom of speech and expression, and there is a right of political dissent also. And the Supreme Court has recognized that right by giving a restrictive view of the order of the word, the directive issued under paragraph 2 of the 10th schedule. And recently in the Manipur case, and also going by other suggestions given by the election commission and all that, there should be layers of functionaries which can decide the disqualification or defection proceedings. And in this case, the court has suggested, and the court also the various authorities have told about the independent tribunal being headed by some retired justice. which should replace the speaker in these cases of defection. So that's all. I would like to conclude my topic now. If there are any question, we'd be happy if there are any question.
Thank you, Nishit, for your enlightening speech. And you have mentioned judicial observations regarding the anti-defection law. So my question to Dr. Vinay Kumar is, Dr. Vinay, do you think that the anti-defection law is against to true spirit of democracy? Because we are avoiding the people not to defect from one party to another party. So everywhere we are highlighting the concept of democracy, that
Yeah, as I've already emphasized about the same, that for the smooth governance, there is a need for a political unity, and there's a need for the legislatures voting on the party lines. Keeping aside it, which it becomes very difficult to identify whether a person X or Y is acting on selfish interest, or whether he is acting on his conscience for the benefit of the people. So it is quite difficult for us to come to a conclusion on this aspect. But as we discussed earlier, that in case of the defection, no policy can be framed by the government. So this may lead to a chaos in the state. So sometimes for the, as said by the Bentham, that for the largest benefit, greatest happiness of the greatest people, taking it into consideration, it is better that the legislators need to vote on the party lines.
okay. Okay, my question to Mr. Nishit Ranjan Chaki. So you talked about judicial observations regarding anti-defection law. And do you think that is there any need to amend the 10th schedule of the Constitution to address this kind of defections?
Sir, actually, what happens is that sometimes we obviously we create law out of the present needs. So when in 1985 this law was made, it was suitable for that Indian society when
Okay.
we were ready to fight defection, so that we never had a opposition vote also that time. But after that, if you see the study of the various commissions, like the election commission I've referred, the working review of the working of the constitution, they all have suggested changes in the process. And as of now, if we talk about, then there, as in my personal opinion, there has been a misuse. There has been blatant misuse of this defection, the provisions of defection. And in order to escape from these provisions of defection, only certain, legal schemes have been legal, not legal. Finding the loopholes of the law has been utilized by the political actors. So yes, obviously there is a need for amendment of this 10th schedule. And in order to amend in this 10th schedule, I would like to emphasize that there can be layers of scrutiny. For example, if the speaker is the first body to decide, is the first person to decide on disqualification, there might be a provision of appeal against his decision. And also there should be a time limit. The specific, it should be mentioned in the constitution that these are the rights, and this is the procedure of inquiry, and this is the time limit within which the speaker should act. The Supreme Court has already emphasized in different cases. So yes, there is a need for this thing, amendment.
Okay, thank you, sir. My last question to Nishit. Nishit, that political parties issues whip. So the whip will have any legal, it is a constitutional, it has any constitutional rights?
Sir, no, sir. Whip does not have any constitutional. No, it does not have any constitutional provision attached to it. But yes, it is a convention. I think that the process of whip that we have been taking this parliamentary form of democracy from Britain, and it is a convention that the office of whip exists, and the office of whip has certain amount of authority, and also the
Okay.
official nature of that cannot get disobeyed.
Okay, thank you. Any questions from the participants? Meghana, Somaya, both of them are doing MA Economics at ICFI,
Okay.
and they are there. Just I'm looking at them. That any questions from the participants? If there are no questions, we will conclude. On behalf of the Sakshi Media Group, we are very grateful to Dr. Vinay Kumar and Mr. Nishit Ranjan Chaki for
Thank
their
you, sir.
exceptional contribution to this event. The expertise of both the research persons. Actually, personally, I am very much satisfied with the performance of these two research persons.
Thank you, sir.
So we are very greatly, so expertise of these two resource persons greatly enriched the experience of our attendees, and we are truly thankful for the valuable contribution of Dr. K. Vinay Kumar and Mr. Nishit Ranjan Chaki. We are also thankful to the participants for their participation in the webinar. And finally, we are very grateful to Sakshi Media Group for allowing us to conduct this kind of webinars for the sake of benefit of the students and audience and academics also. Thank you very much, Dr. Vinay Kumar and Nishit Ranjan Chaki.
Thank you very
Thank
much,
you.
sir. Thank you for
Thank
the
you, sir.
invitation. Thank you to
Thank you,
the
sir.
Sakshi Media Group for organizing this program. Thank you very much, sir.
Thank
Looking
you,
forward
Nishit.
to meet you personally whenever I am in Hyderabad.
Thank you, sir. Thank you. I will also invite you both